since '91, and I was the first minority lawyer at the firm, which I think is pretty cool. We've developed, if you look at our firm now, we have all colors, all sizes, and women lawyers. We used to not have women lawyers. And we have all of that, and we're trial lawyers. Just like Charlie, you're trying to narrow what you do. We're still wide open. We do a bunch of personal injury stuff, all kinds. But one of the things that we do, you may have heard of my law partner, Randy Sorrels, who's the next president of the state bar next year. Well, because of the way we do things, I happen to be the next president of HBA, and he's going to be state bar president, so we're taking over. Don't tell nobody, but we're taking over. So, pleasure to be here. I'm a bar junkie, and I've turned in my card to join y'all since I'm so close. Why not? And we need to do things together. I think we were talking about it. The Houston bar is downtown, which is harder for some of the lawyers that are over here. But we can bring events out here if we plan it. And having me out here certainly is going to be a good way to collaborate. So we're going to do that, and we're planning on it. All right, so my topic, I give a lot of CLEs. I'm a former school teacher turned lawyer, so I love teaching. And this is going to be a quick, many topics put together. I have called it the witness background issues. So it's different issues on witnesses at trial. I'm a trial lawyer, so I'm going to be guiding you through some of those. But the first thing I'm going to show you is a very short video in a real case that I had, and I filed suit, I asked for discovery, I asked for the dash cam electronic data, and when I got it, you'll find out what I did with it. All right, so very quick video. Defendant driver has a dash cam driving. My guys, two workers are doing some construction, road construction, and but guess what? Did you notice anything? All right, can you back it up real quick, just a little bit? It's very short. He's talking to his wife. The driver's talking to his wife, totally distracted. Watch the rail here. Bam! See that guy? Well, that's it. Before I filed suit, the police report says they're in the car. The incident report says they're in the car. The statement to the insurance company for workers' comp, because they were working when the truck hit them, they all are in the car. So I'm like, dang, sounds like a pretty good commercial case. They're injured, claiming all kinds of injuries, clear liability. As soon as I get this, I'm telling you, within 3 seconds, I'm calling the guy and I'm dropping the case. I'm out of the case. Well, why? You said you were in the car and you're sitting outside the car when the accident happened. I don't want to imagine spending all the money you have to spend to litigate this case and start depositions and all this nonsense, and that's what happened. So I'm glad there was a dash cam video, and I'm glad I was able to get out of it. So those are the things that happen when you have to face trial, and unfortunately you either are prepared or not, or you're lucky to get the dash cam. Some defendants maybe would have held it back as long as possible and dropped it on me. I'm glad they gave it to me first thing. And that same day, as soon as I opened the video and saw it, I called my associate on the case. Did you see the video? Yes, I just saw it. Get me the clients on the phone, and I dropped it. I got out of the case. That will make my career go longer. I may not have that case under my belt. I'll go work on another one, but I got rid of that case. I did file an intervention because somebody else filed suit, because my expert did all the download electronic data and stuff, so I'm like, you know what, if somebody's gonna get paid, I want my expenses back. So I filed an intervention. All right, so we got till when? When do I have to cut it off? At 6 o'clock?
5 to 7.
Well,
6:55.
All right, so I have enough slides, but I'm not gonna prolong it. I'm gonna try to get quickly as you eat. So I'm a trial lawyer. I have spent my career studying juries and working with juries. I do focus groups in all major cases. I do mock trials in the real big ones. And I do it even before we start some cases before I file suit, believe it or not. Because I want to learn before I take my first deposition what issues I'm going to face and what juries like, what they focus on, what they think is important, and what is not important. And we had a floor collapse in a church's chicken that burnt some people, some workers with oil. It was a horrible, horrible injuries. So I spent all this time with all the experts to discover the facts, and I knew I had a good case. So immediately before I started taking depositions, I went ahead and did a lot of focus groups to learn what were the issues, because there's going to be a lot of blame. So you learn. So focusing on what your jury looks like, prospective jury, what the good jurors are going to be, what the bad jurors are going to be, is important. So I'm going to take you through first understanding the issues of trial and what jury perspectives are. It's very easy sometimes to think I have a good case and not pay attention to what negatives may come out. For example, I just tried a case in South Texas. I couldn't believe when I was picking the jury how many folks, it was an 18-wheeler case, and I couldn't believe how many folks had family members or owners of trucks. Well, then you start thinking, duh, you're in Hidalgo County, they're going back and forth across the border, there's drivers all over the place. So I had to really readjust my thinking, because there was women that said, my dad has been an 18-wheeler and raised his family driving 18-wheelers. So I hope she's sympathetic to my client who was involved in an 18-wheeler wreck. But then I started thinking, are they going to really go hard against the 18-wheeler company when I want millions of dollars for horrible incident? So you have to think through that, and the focus groups is the best way to do it. It's pretty cheap. In fact, the trial lawyers now downtown, they're giving you free attempts at focus group with some trial lawyers listening to it and giving you input. So there's many ways you can do it, but I usually hire a professional jury consultant, and sometimes I'll do, if I want to go cheap, I'll get the Employment Commission to send me some folks. I have somebody who helps me get that. We get about 10 people come to my office. I pay them for the day, and I do a quick focus group with some questions, and you won't believe how much you learn in a cheap way. And it doesn't matter. It could be a commercial case. It could be a PI case. It could be a defense, or it could be a plaintiff. It doesn't really matter. But it's something worth doing if you're going to be getting ready for trial or a big arbitration. Some folks were saying arbitration. The same thing applies to the arbitrator. All right. I want to start with Cortez and Hyundai really quick. Now, they've been around for a while, but there's always a trap. When you're picking the jury, you think, well, if I just tell them, I'll figure out who's bad. Like in the Hyundai case, there was a seatbelt around the baby car seat that was not put on the car seat. There was a horrible accident. The child was thrown and killed. So in that case, they decided, well, maybe I'll tell the prospective jury, the veneer group, about not having the seatbelt and see what they think. Well, everybody's going to say, if you don't have the seatbelt, you're out. I'm against you, so to speak. So then they wanted to go do peremptory strikes, not peremptory, for cause strikes, because everybody had made up their mind. And then the appeal says, wait a minute, if you're going to bring in the facts of the case, you can't get for cause. You're going to have to use your peremptories, and then you're done after 6. So what I say to you is be careful what you bring up. Some judges won't let you, flat out won't let you. Some judges will say, hey, it's your call. But you're not going to get for cause once the jury starts committing to your facts of the case. The best thing is don't bring it up. And if it's a really bad issue like the seatbelt, protecting the baby in the car seat, not having a seatbelt on, then do your focus group, do your homework, and figure out which is your worst jurors and try to get them off by cause and then peremptory. But if you bring it up first, you've given it up. All right. Quickly, cross-examination of witnesses. Everybody who's a trial lawyer understands that, but I'm going to bring you some examples how this becomes real in your case. Of course, I tell my younger lawyers, everybody knows the rules. So we study the rules. We were talking about O'Connor's earlier, a former lawyer of our firm, turned judge and turned author and turned millionaire. Good for her. But everybody knows the rules. But when you walk into the courtroom, I tell folks, nobody's going to know it more than me. They may know as much as me, because the rules are the rules. So if I walk in and you know the rules and I know the rules, we know them. but I'm going to be as prepared or better prepared than anybody. So be prepared for that if you're going to trial, or you're going to be, the arbitration rules are different. You have to be prepared for that and understand the rules. So what happens? We're in Texas, there's construction, there's road construction, there's people working. I represent injured folks and families of injured folks. So one example, down I-10, they're building a church. They're digging for conduits, to put conduits down here to bring it to the new construction, electrical conduits. If you know construction and you see this, what are you thinking? It's going to collapse.
OSHA violation.
I mean, look, OSHA violation. This is built right on the edge, so the piling needs to be back further. They're trying a really bad job of stepping. You either slope it or step it. OSHA gives you exactly the dimensions, how you're supposed to do it. And of course, what do you think happens? The guy's buried alive and dies right there. So this is what's happening. And we tried this case in front of, this is a long time ago, but in front of a judge, is now a federal judge. And we were successful, but what I bring to you is the examples of what's happening in Texas and Houston all the time. There's a lot of construction, there's a lot of workers. But what happens? The immigration status is a big issue. That gentleman that was buried alive was from Mexico and was here undocumented and was working, as you can imagine, with fake name and fake papers. And so I have a paper in a law review much longer than what we're going to spend tonight. I start with this because this is what a lot of people know me for. I've done a lot of research on this issue because of the clients that I've had. And this line right here is straight from the Supreme Court, Texas Supreme Court. And this line, believe it or not, is from 1889.
Wow.
The Texas Supreme Court in 1889 had this line, and it kind of sat around there until 2010, when Justice David Medina pulled this line out of the old cases and put it into a case called TXI versus Hughes. And the TXI versus Hughes we'll talk about in a second. But clearly, the immigration issue is a hot topic in our everyday politics and our everyday life. And I have a strong opinion about that. I believe in strong borders, safety to our borders, and that's America. But at the same time, America tells us that if you're here and you're working and I back up a truck and run you over and kill you, we have to separate those issues. And so that's what I have to face in all these years that I was trying cases where my worker minding his own business gets killed, unrelated totally to his immigration status, and this issue came in, or I had to fight it. So I bring this to you because I tell all my lawyers, hey, I'm a Hispanic lawyer, I speak Spanish. There's a bunch of Hispanic workers and a bunch of Hispanic people in Texas. How many are your clients? And from the group that I recognize here tonight, they're not all workers. There's business owners and all kinds of people doing business from Mexico, from Central America, from all over the world. We need to be aware and ready to jump in and participate. So this is an interesting line. During the past 100 years, Texas appellate courts have condemned arguments that invoke prejudice. That's in a footnote out of a Court of Appeals case from San Antonio. And when I'm doing all the research, I find that footnote. I'm like, what are they talking about? The past 100 years? I haven't seen any of those cases. And then I started digging, and that's where I found that 1898 or 1889 opinion from the Supreme Court. So San Antonio did the research for me. And in those days, obviously, they were talking about other things, not so much the undocumented worker, but the point is the same. You can't just prejudice a litigant or prejudice someone just because of their background. You had a question?
Real quick, while you're on the topic. If someone is illegal, is it something that is properly presented, or is that error if it's presented during the course of the trial, with or without a jury?
And without a jury, no error.
Right.
The judge is smart enough that she can put it aside.
Right.
In labor cases, for example, labor cases, there's no jury. That comes in all the time. In an arbitration, for example, the arbitrator is smart enough to know if it affects the case or not. You can put your briefs in front of the arbitrator, and then no big deal. The jury is the problem. And with a jury, it is automatic reversal.
Okay. That's what
Automatic reversal. It wasn't the case until recently, and I'll go through quickly through those cases. All right, so let's talk about TXI versus Hughes. It's the first case in Texas that brought it up to light and directly approached the issue. TXI versus Hughes was a Fort Worth County, a Tarrant County 18-wheeler wreck where the 18-wheeler driver was undocumented and he T-boned the Hughes family and killed 2 people. The jury verdict was $18 million. It went on appeal to the Supreme Court. Interestingly, because the plaintiff is the one that brought it up over and over during the trial, about 60 plus times during the trial. The illegal alien driver or the undocumented driver, they just kept on bringing it up. I frowned upon that, but certainly that's what happened. As soon as I saw it go up on appeal, I said, great, this case is going to be heard by the Supreme because they're going to reverse that $18 million verdict. That was my mind. I'm thinking, at least they'll bring it to the table. When they brought it to the table, this opinion came out. It said, you can't impeach the witness just because the driver is undocumented. There has to be some connection with the facts and the negligence and whatever it is. So they reversed and remanded the $18 million verdict. When it went back to trial, they kept that issue out. It was a pour out because the issues were contested, whether they crossed the yellow line, whether a bunch of experts testified. But when the jury actually heard that that guy was undocumented and shouldn't have been driving, and all the emotion that is built behind that, which I understand, but that shouldn't be in the courtroom. That should be maybe public affair, public issues, and we can argue about it all day long. But in the courtroom, whether the family was T-boned and killed because of the negligent driver or negligent training or whatever you want to say that's negligent, the fact that he was undocumented really didn't make a difference. And so the court said, for impeachment 608, 609 purposes, you can't bring that up. That's not the reason. And so I bring this case to your attention because it's brand spanking new. This spring, 2018, a good lawyer from Houston, Arnold Lincoln, is in South Texas trying a case. In the middle of trial, the defense lawyer brings up the status of the plaintiff, and that's all they say, status. But if you're the jury and you start hearing about the plaintiff's status, you're like, what? What's he talking about? He must be illegal. And you start thinking that, that's what juries do. I focused it a million times. Good American, red-blooded American are good people that are going to be fair as soon as they hear that word. And I'm not saying you're unfair, but you're so inflamed by it that as soon as they heard the word status, they turned. So the court said, the 13th Court of Appeals said that, as TXI said, whether it's blatant or brazen or just subtle, if you bring up the status for no other reason than to inflame the jury, it's automatic reversal. So that's what is the culmination. They cite, the 13th Court cites TXI and cites my case. And I haven't talked about my case, but you'll hear my case in a second. All right, so going back to TXI, they're talking about specific instances of conduct. 609, we've talked about that. Justice Medina actually raises the language from the old case law. Again, in those days, it was more racial, and here it's racial. In the more modern cases, racial and national origin. It becomes more national origin. If the person's undocumented, that's more national origin. But nonetheless, he brought it up. And that was in 2010. While the 2010 was going up and the opinion came out, I had tried a case in Harris County against Republic Waste. A worker is a garbage guy. He's from El Salvador. He had some fake papers. And remind me to tell you what the issue on the fake papers is. So he's working, he gets run over and killed. I tried the case, Judge Wood, probate court, Sherilyn Wood's husband, Mark Wood, he tried the case and man, we fought about whether it's coming in or not it seemed like for days. And he finally, don't tell him, but this is what I think he did. He said, I'm taking a break, I'm tired of listening to you all. So he went back and he comes back from the break and he says, nothing's coming in. Not one side or the other, because I said, Judge, if you let them talk about my alien status, I'm going to tell them that I cited them for $3 million because they had 50 workers at the plant, picking up trash. So he said, nothing's coming in. I think he went and called his best friend, and she said, None of that comes in. That's his wife. That's what I think happened. I won't repeat. I'm going to call you liars if you repeat that. But I think that's what happened. It makes sense. He's like, man, this battle is driving me nuts. We're both arguing, opposing counsel and I, with the judge. He came back from a break, really calm, and said, nothing's coming in. You don't bring it up. You don't bring it up. Try the case. Why did this guy get killed, and what are the damages? So that was my case. We got, a few $1 million, 1.4 in lost wages, because we have an expert presented lost wages. He was a young man in his earning capacity. He lost 1.4 mil. The jury gave me every penny. So they appealed that. And in this opinion, in front of 3 female judges in Harris County First Court of Appeals, Judge Higley wrote the opinion. They said under 403, it may be somewhat prejudicial. They went more than I wanted. I said it's not prejudicial, somewhat relevant. I said it's not relevant at all, Judge, just read all the cases. So it may be somewhat relevant, the lost wages to the ability to work here, but it's so unfairly prejudicial that under 403 it's coming out. And then they had the Supreme Court unanimous opinion from a year before, which of course I bootstrapped into the opinion. So what has happened is that the law now, as it sits in Texas, is that under 608, 609, the Supreme Court said unanimously, you can't impeach a witness on an irrelevant matter not related to the case. And under my case, you can't bring it up for lost wages because they're entitled to it. And in a bigger paper about immigration that I have, which we're not going to get into, there's cases all the way back to 1939 in Texas. They kind of talked about incurable jury arguments. And then in 1993, an El Paso court said in a footnote, the first time it ever showed up in a footnote, said alien status or citizenship is not relevant against lost earning capacity. Either you have a capacity to work or not. And then I used that case as it went forward, and we culminated in this opinion, which I'm very proud that we were able to do it since I've been working on this for years. I mean, literally writing law reviews and fighting it and figuring it out, and then finally a good case, good Lord let me have a good case that went up. So that's where we are. This is the same thing we've been talking about. So when can it be used? Because I say it should never be used. Never comes in. And so far so good. I've been successful. But when can it be used? I'm going to give you a Texas case called Bustos. In this case, it was in Harris County. Levi Benton was the judge. And the facts before the judge was that in those days, the DA was going after folks that had these papers that were fake. Remember we talked about that? And the DA actually convicted the worker for fraud. In those days, that's what people were doing. And it sounds right? I mean, if they're fake, isn't it fraud? Well, they convicted this guy of fraud, so when it went up on the civil case for injuries, the court said, well, since you have a fraud conviction under the rules, I can impeach you. So the Court of Appeals says, yeah, if that's the case, then it comes in. So that's when it comes in, if you have a fraud conviction. I don't know if I have the case. Let me see. No, I don't have it. In my other PowerPoint, when I give the bigger topic, there's a U.S. Supreme Court. The U.S. Supreme Court, in a case called Kentucky versus Padilla. In that case, the Supreme Court said that having false papers is not fraud, believe it or not. That's what the Supreme Court said, because you have to prove intent. To have fraud, you have to have intent. That's a legal element. And unless you prove the intent to defraud, it can't be fraud. So that Bustos case kind of went up in the air as far as the DA's case, but that person suffered that consequence. If I have a case now, unless there's conviction of fraud with the proof of intent, the Supreme Court told me you can't prove fraud without intent. So for folks that are here with undocumented papers, it's not fraud. It may be wrong. It may be undocumented. It may be all kinds of things. But unless you prove intent, you don't have fraud. Interestingly, in my case that went up, the Martinez case versus Republic Waste, he did have fake papers and fake name and all that. You know how I figured this out? I did a mock trial with Robert Hirschhorn, which is like the most pricey guy, him and Lisa Blue. They asked for tons of money, but I knew it was a big case, so I hired big dogs. And the phrase is this, the employment name. And of course, the jury never heard it, but for me to argue to the judge, I had to come up with a phrase. So the phrase was, that's his employment name. I mean, he needs to work. You don't want him to be a bum. You don't want him to be stealing and robbing and being bad. So his employment name is this, and we scratched his fake name off of every paper we had, and it was part of the case. But when we did the focus group at the end, the jury gave me a bunch of money, so we were confident, okay, we're going to win this case if it goes well. At the end, Robert goes up to the gentleman standing up front and says, "Sir, let me ask you this." And the group like this says, "We've told you, you've came back with the verdict. Thank you for your help. This really helps our case. But if there was one fact we didn't tell you, if I were to tell you that the man was undocumented, would that make a difference?" And the face of the guy got red. He punched the table. I give him nothing. And we're videotaping this whole thing. We were like, whoa. So sure enough, we have to protect our juries from themselves, so to speak, because you want to be fair. The juries want to be fair. But once they hear something that's inflammatory in our hearts because we have strong opinions one way or the other, that has nothing to do with what happened, you're normal. You're going to get inflamed. You're going to get upset. And so we got to protect that. And so thankfully the cases have allowed us to do that. All right. This is another way that it's been tried to go bring it in. And it's in a motion summary judgment, they were trying to get, it was a case against the Border Patrol, and they tried to use what's called the unlawful acts rule, unlawful acts doctrine. I don't know if you've heard of that. If somebody commits a crime and goes to jail in Texas, there's a law that says you can't benefit from it. So if you write a book, you don't get the money. And that's for that purpose. But some smart defense lawyer said, you know what, the unlawful acts doctrine is a law in Texas, and if you're here illegally undocumented, you're committing an unlawful act, and by golly, you can't benefit, so we're going to bring that up. And that was pretty darn good defense, I thought, but it got thrown down. The federal court said no. That's generally the rule, so I'm going to pass through that. Oh, back up. Let's see. No, it's not there, but there's a Texas case that came out, and it was a weird case. There was a shooting and people chasing each other, and there was drugs involved. It was called the Bergeron case, and I may not have it here, but it's in the other illegal alien stuff. But the Supreme Court said that it's irrelevant, and unlawful acts doctrine doesn't apply to this case of undocumented workers because, believe it or not, IRCA says that if you're here undocumented, you're not violating any criminal laws. That is the law in U.S.
IRCA? What's IRCA?
The Immigration Law Act.
Okay.
So the immigration law in our country stripped out the criminology or criminality of being here undocumented. So if you're undocumented, you're just undocumented. If you're here after being deported and you come back after being deported, now you're a felon. So that's what the law says. So the Texas Supreme Court said, look, it's not a crime to be here undocumented. You can get booted. If they catch you, you're going to get deported, but not criminality. So they struck the unlawful acts doctrine as not the case. And so that's been what they've tried. Before I get into the criminal side, and I think we're going good on time, there is remember I mentioned labor cases? There's a case called Shurtan, and there's a case called Hoffman Plastics. Those are two U.S. Supreme Court cases. The Hoffman Plastics case is the top one, both written by the late Justice Rehnquist, wrote both opinions. But in Hoffman Plastics, the issue was, and the conclusion was, that the undocumented person takes no future lost wages in a labor case, labor law violation. And all the defense lawyers, this has now been over, but for many years they kept on bringing that U.S. Supreme says if you're undocumented, you don't take future wages, and here's the case. Thankfully, Justice Rehnquist put one line in that big opinion, and I kid you not, one line says, this does not apply to personal injury cases. Because labor cases are non-jury cases, labor cases are administrative, and of course, if you're asking for a labor violation, past wages and future wages under the labor code, and you've been deported or you can't work here, but you don't get future labor. In most personal injury cases, lost earning capacity is decided by the jury. You just put forth what the person, either because they died they could have made, or if they're alive they could make with some restrictions, and the experts kind of battle what the real lost wage loss is. But the undocumented issue does not apply starting from 1993 in the Cordova versus Walmart case that I told you about in the footnote, ending in 2003 case from Tyler, I believe, and it's called Guzman versus Tyson Foods. And so in those 10 years, after Hoffman Plastics came out, finally the Court of Appeals from Tyler said, well, look at what Justice Rehnquist actually said. It doesn't apply to personal injury. So that kind of went away. But it was a battle that we constantly had to deal with. The unlawful acts doctrine was the last thing that we've been dealing with, quite innovative, and thankfully we have an opinion to clear that up. All right, so we're talking about witness background issues. We told you about the lying witness. What do you do with that? You just drop them. We talked about the alien status and what you have to do, whether you're on the plaintiff side or the defense side. But obviously, I'm on the plaintiff side, so I've been fighting it. And thankfully, we have that. In the criminal background, just generally, courts have to balance the criminality of your witnesses. It could be the plaintiff, it could be an eyeball witness, it could be the defendant. So that makes sense. 404B, we learned it back in law school, still is the rule. I mean, I was in trial recently and they tried to bring in 404A and it was wrong. It was 404B. And still they couldn't bring in a bad act. But bad acts obviously can come in from in other ways. Just because somebody committed a bad act doesn't mean it comes in automatically, but there's other ways. Now, a prior conviction, I go way back to 1967 because it's been the rule. A prior conviction on its own is not evidence of what happened. Okay, it's unfair prejudice. It could be unfair prejudice, but you have to decide if it's relevant to the case or not. The judge decides that. All right, so now let's go to a recent case, a negligence case out of Tarrant County, when a prisoner sued because he was hurt while being transported. And witness credibility is at issue, so prior convictions may be admissible. That's the same thing. From a criminal rule, everybody understands that. From a civil side, of course, it depends on the case. There's a 10-year rule for felonies. Somebody called me today exactly on that, and I was giving them some advice. Well, there's a lot of criminal activity. Is it outside of 10 years? Is it moral turpitude? Is it a felony? All of those issues are taken into consideration. And of course, you can ask the judge to keep them out, even if it's within the 10 years. All right, so car wreck issues. Unlicensed drivers and admissibility of seatbelts. The seatbelts issue is something relatively new. Do y'all remember that? In the old days, when I started practicing, it was inadmissible. If the person was wearing a seatbelt or not, never came in. It was in the statute. Y'all remember that? That was the rule. You're not wearing a seatbelt? Who cares? Why? Because not all cars had seatbelts. Seatbelts were kind of messy and crappy, just something to put on that bothered you, so you put it behind you, right? So seatbelts was not part of any civil case before. Unlicensed drivers, we'll get through that. So we see 18-wheeler cases in Harris County. We see truck cases. We see car wrecks. Heck, we see so many car wrecks, people calling, that, I try to, commercial cases, we try to get the ones with big policies, obviously. Our younger lawyers, we put them to work on the smaller cases. That's how you cut your teeth. That's how I started practicing. Car wreck cases, rear enders. Every once in a while, I'm like Nichols says, my law partner, he said, hey, just send me a good whiplash case. All right, I'll cut my teeth. I'll get back in the courtroom. So that's fine. That's what us trial lawyers do. Prior driving record, I mentioned that since we're talking about car wreck issues. And again, you can't say you ran the light 3 times and you got 3 tickets or 10 speeding tickets. That doesn't come in just to show that you ran the light here or were speeding here. You can use it for either a pattern or excuse me?
Oh, I'm sorry.
No, whether it's a pattern or a habit. I mean, there's different ways that you can try to show, but it's not easy. I mean, we all, in Harris County, we're driving the freeway, we're always speeding. Okay, the point is, I tell my kids this, there's a drunk driver, we're gonna get to drunk driving in a second. There's a drunk driver and a speeder going 100 miles an hour, swerving left and right all the way home. Are they negligent? Well, no, they haven't hit anybody yet. You have all the elements of negligence. You haven't hit anybody yet. So when you hit somebody, then you're grossly negligent, right? So yes, you can't prove it, but that's obviously an issue. A lot of people say, oh, you got 10 speeding tickets. I try not to get too excited with a truck driver that has a lot of speeding tickets. Of course, they should not retain them. There's other ways you can get in. The employer should say, well, you're getting all these speeding tickets or racks, then you're out. You're not driving my rig. So I think when can it be used? We've been talking about it. There's ways to get it in, depending on the circumstance. So let's talk about the unlicensed driver. 1985, the fact that somebody is unlicensed is not coming in automatic. And I deal with that with my undocumented workers, because remember, over 10 years ago, if you're here undocumented, you can go get a Texas ID, and some people got Texas driver's license. Now, they changed it. You can't get not even an ID, maybe an ID, but very rarely, for sure you can't get a Texas driver's license. If you're not documented here, you don't get it. So people are driving, get wrecked, and even if it's not my fault, when somebody hit me, the other side wants to say, well, you're not licensed. That's not an issue. The issue is the standard of care. Am I driving like a reasonable, prudent driver would have driven under the circumstances? And if you can prove a violation to the standard of care, the driver's license makes no difference. If I ran the red light, with or without, doesn't make a difference. I have a case I just signed up where the guy gets hit by a security company in Dallas. They called me up and I went, started talking to the guy. Seems like a very good case, bless you. And as soon as I get the medical, the guy's been drinking. So my guy's, I'm not gonna say smash drunk, but he's had a few drinks. But he's walking from hotel to hotel downtown with other witnesses around him in the crosswalk. So who cares that he's been drinking? The defense is gonna bring it up, of course, but I'm gonna say that didn't cause anything. Here comes a truck, a security truck, runs him over because he wasn't paying attention, missed the other people in front of him and hits him and breaks them up, bones and injuries. So, those are the issues you have to deal with.
Question.
Yes, sir.
Drunk in the crosswalk, irrelevant.
Right.
This can be limited out.
Yes.
Yeah, okay.
Yeah, I remember a case I tried where my boys, my plaintiffs, 2 young men on July 5th. So picture this, July 4th, drinking all day. Morning of July 5th, they closed the bars or the gas station at 2. They live in East Houston, so they know what door to knock, and they get a 24 pack of beer after hours. Some neighborhoods, they do that. So they get a 24 pack, give them the money, they're on their way back to the house to keep on drinking because they are having a good time. They stopped at the red light, they're waiting for the light to change. As soon as it changes, they start going forward. Here comes a wrecker driver going 65 and T-bones them and kills both of them. Passenger in their back survived, and that's how I got the facts. They were drunk, falling down drunk. But I was able to file a motion for summary judgment against the fact that they didn't contribute to anything. A normal sober person would have seen the light change, start going, and here comes the wrecker and hits them. And I got that, and the case settled for policy limits. So you have to prove that it contributed or not. And there's case law. I'm not making this up. There's old cases with trucks hitting other people, and the person that's drunk is not doing anything wrong, but they get hit by a truck. So there's a lot of cases. I didn't make it up. I found cases and used it. So a licensed driver, pretty clear. Seatbelt usage, not so clear. It got muddied. This is an old case. Make sure I'm good on time. Yes. This is an old case. In the old days, it was absolutely struck. You couldn't bring it in. The person wasn't wearing a seatbelt. Motion eliminated, but the statute and the cases said it, so it was real easy. When I started practicing, that was the case. So every time I had a car wreck, the police officer or somebody said they weren't wearing a seatbelt, who cares? The statute changed. And the statute says now that it's not per se admissible, but what it draws, the question that begs to be answered is, well, did it contribute to your injuries? Okay? And in rollover cases, which is the ones that are really crucial, if a person's belted or not, and a car rolls over, a truck rolls over, If you're not belted, you're flying out of there. And sometimes the truck rolls over and smashes you and kills you. Had you had the seatbelt, you're gonna be injured. Hopefully not a crushing injury, but you're gonna be injured and you survive. But if you don't have the seatbelt or a child is not buckled into their car seat, they're flying out of there. So the injuries are worse, and I've seen car manufacturers make a big deal of this when they do failure analysis. If had you been wearing your seatbelt, you would have survived or had less injuries. So seatbelt now, it comes in not to show you're a bad person or you're violating the law like the driver's license, but it comes in to show contrib or mitigation of injuries. And that's huge in rollover cases or serious injury cases. I had a case where head-on collision, my guy's waiting to turn left, here comes a truck, loses control, he's driving too fast in the rain, hits him head-on and kills my guy. He was not wearing a seatbelt. But it was such a severe impact, he would have died with or without the seatbelt. So we had to fight to keep it out. And the experts, contrary experts, tried to bring in the fact that had he had a seatbelt, maybe that would have helped, but there's no way. He was killed on the spot. So those are the facts that come in, and seatbelt is a big issue. This is, okay, another seatbelt case. And so in this case, in the federal case, not having a seatbelt, it's a case-by-case scenario. But I think that because the statute says it may not be kept out, in other words, it gives the option of whether it comes in or not, then on a case-by-case basis, the court is going to rule on it. And the issue, as you see very clearly, is whether it contributed, okay, and gave rise to contributory negligence. So did your not having your seatbelt contributed to the wreck or contributed to your injuries, and or if that's contributory negligence? And I think most juries, if I focus this just in this group or with any group that you want to focus, most folks are going to say nowadays seatbelt is automatic. If you're not wearing your seatbelt, you get into a wreck and your injuries are worse because you didn't have it, the jury's going to go that way. So that's something to keep in mind. I show you this slide because I've been using this a lot more. Trials now have become visual, right? When we try cases, there's PowerPoints, there's videos, there's animations. I love animations. I get my experts to do them. I love day-in-a-life videos, like mini documentaries of my clients. It just gives the jury more reality. But I've gone as far as using little tricks. Like I'm suing Benny Keith. Benny Keith is a massive food and beverage distributor. And some horrible incident occurred, I'm suing them. And so the first thing I did, I got pictures of the plant, the facility. I'm driving downtown and I see a Benny Keith truck. I take out my phone, take a picture of the truck. And I'm thinking, what do people see every day? You see the trucks, you see the commercials, you see potentially the facility. So the more you put that in front of a prospective juror or the jury, they're going to now understand more and more who the defendant is and have certain images of you. For example, in a surgery case, I show pictures for demonstrative purposes of the inside of an operating room. I mean, if you've been inside an operating room, operations, OR, they're pretty scary. There's equipment everywhere, there's lights everywhere, you're staring at it as they put you under. So when I'm talking about this lady, client of mine that had to go to surgery 3 or 4 times to repair her broken leg and how horrible it was, if I just talk about it, show some medical records, yeah, she broke her leg. But if I show this kind of thing, an x-ray, unless you're a medical doctor, you don't know what you're looking at. I certainly don't. But if you colorize the x-ray, that's impactful. It's like, wow, that's what really happened to the lady's hip? It's huge. Compared to this, I'm not sure I understand what I'm looking at. Here I do. And this comes in, I wrote a paper on substantially similar evidence. It comes in, if you prove it up right with the expert, it's substantive evidence. If you don't do it timely or if you're unsure, it's going to be demonstrative. So easily proven up and easily put in front of a jury. This form of showing the injuries, very impactful. More recently, what I started doing was somebody who has a lot of broken bones or a lot of injuries, I do the same thing but put it in a PowerPoint presentation where it clicks, but it sounds like a crunch. So we start from head to toe. Fracture, crunch, it does its own little sound. Click, crunch, click, the next one. And I keep on showing all the red spots in the body, broken bones, and interact with the whole body view with this. At the end of the presentation, you know the person's all beat up. I mean, there's no doubt. There's a lot of broken bones in this body. So these are simple ways to present your evidence to the jury with a doctor, with a right practitioner, easily done. All right. When it could be used, demonstrative, substantive, I told you that. And we're good on time, but I'm going to quickly tell you my last trial, last month in South Texas. I go take the doctor's deposition, total knee replacement. So I'm thinking, great case, great damages. I notice the doctor's deposition. I show up. I tell his nurse, hey, can the doctor talk to me for 5 minutes? I just want to make sure, go over the chart. Nobody shows up. Nobody comes out. He comes out, shakes my hand, sits down. So I start asking questions. 5 minutes into it, he says that my client's knee replacement, based on reasonable medical probability, is not related to the wreck. In the records, it said it was. So I'm freaking out. I'm like, oh my God, trial's coming up. And this is the video for trial. I am doomed, right? So after I picked myself up from off the ground, I went ahead and figured out, God, give me wisdom. Well, exacerbation, aggravation, there's other ways to prove up the same thing. My client was a Vietnam vet with many years of knee problems, arthritis for many years, injections, and all kinds of treatment. Nobody said he's going to need a knee replacement. But once he fractured the tibial plateau, which is a really bad fracture, almost always leads to knee replacement. The doctor even said later in the depot, when I finally twisted him enough to tell me, more likely than not, those kind of fractures end up in knee replacement. When you have a long history of osteoarthritis combined, of course, that's going to lead to it. And he had it 3 months after the wreck. So obviously, it had something to do with it. But I almost died. I mean, that's my damages, and he's kicking me in the butt. He's kicking me to the curb. So, but in that case, again, I had the video presentation of what a knee surgery looks like, and you open it up. I didn't know what it was. You cut here and you cut here, you pull it out, you put a metal one in. It's like weird. But I learned something, and the jury learned something too. All right. Substance abuse, general impeachment, habit evidence, we talked about that, and causation. So I'm going back to finish up with what we talked about. The motion in limine, obviously, is where if it's something bad, you bring it up, you brief it, you argue it. It was in a motion in limine that I learned there was cases that said that if it didn't contribute or cause the wreck, who cares if they were drunk? And literally, there's cases like that. So I use that to bolster my case. And I sometimes get aggressive with stuff to bring the issues to the table. So that's when I filed summary judgment. They didn't have an answer. Because if I'm going through a green light from 0 to 10 miles an hour and I get T-boned by a flying truck, what did I do wrong? Other than maybe I shouldn't have been driving, but that's a bad act that shouldn't come in unless you did something to contribute to your case. So that's generally where we start. This is a workers' comp case regarding the exclusion of evidence of prior drug use. Remember, in the old days, workers' comp was like a regular civil case, but even today, workers' comp cases are held to the same evidentiary standard, so we can use those cases. It just doesn't come in unless you have a person who's high on something when they're working and they fall off the bridge. I mean, that's directly related. But the fact that I was smoking pot yesterday or doing coke yesterday, God forbid, something bad like that, I have to hire a toxicologist to look at how much the shelf life of the drug in the body so we can figure out how long it was in the system. And there's all kinds of messes that you have to go through if you have a severely injured plaintiff or worker with some drugs in his system or her system. You got to study that carefully with a toxicologist. But it's doable, and unless they were high, smoking weed in the parking lot and came in and fell off the bridge, then you can keep it out, or at least fight it. Habit evidence, we talked about earlier. This is law school stuff. I've never seen habit evidence come in. Okay, we talk about it, we argue about it, but the rules are there. So I would suggest if you have somebody who, every lunch hour goes and smokes a joint and comes back to work, and that's a habit, and somehow it could be proven as a habit, then maybe you can use it. Or somebody driving to the liquor store every night, picking up a six-pack or a big bottle of beer and they're drinking it, and an hour later they're in a wreck. I mean, you can show habits, but it's very difficult. Obviously, drinking and driving and having folks drinking during and before and after work is crucial. We have a 1991 case where the court held that although the evidence of intoxication alone does not establish negligence, that's what we've been talking about, the proximate or proximate cause, it is a factor that the evidence must be considered by the jury. And that's a 91 case. When I started doing this, it was before 91 that I had cases like this. So I bring this to your attention. All right, I'm going to finish, I think, with mental anguish. Mental anguish has evolved. In plaintiff cases or in damages cases, mental anguish used to be simply a laundry list of things in the pattern jury charge. Aggravation, humiliation, frustration, irritation. They had like 6 different things. If you can prove one of those, I thought I won. Okay, were you irritated having to go to the doctor 5 times a week? Yes, I was very irritated. Okay, I have mental anguish. That's the way I used to think. The Supreme Court has changed that, so you got to be more careful with that. The Supreme Court has said, not in this case, this is a more recent case, but the Supreme Court said that it's the destruction or interruption with enjoyment of everyday life activities. So you can prove the same aggravation, irritation, humiliation, all those things, but you got to be very careful how you have your witness phrase it so that you can keep it when it goes up. If you just say I was irritated, the Supreme Court is probably going to kick it. So be very careful with that. So the plaintiff must prove direct evidence of the nature, duration, severity of mental anguish, thus establishing a substantial disruption in the plaintiff's daily routine or everyday life is what I like to say. The enjoyment of everyday life. Hey, I was preparing a witness today, a client for a deposition, a law professor of all things. She was in a wreck, and I was talking to her about this, and in her own words, she was just telling me, going to the doctor 2 hours a day for therapy and all that as I was recovering, that really screwed my day up. I couldn't go jogging, I couldn't do this. She started telling me all the stuff that interrupted her everyday life. How did that make you feel? Or very irritated. I said, perfect, let's think through that, because that's how you have to present it. But if you just say the magic words, the Supreme Court said no more magic words. This was a case, funeral home case, I remember this case now. Negligent mishandling of a corpse. Probably we know who handled that case. The plaintiff lawyer, not me, but if you mishandle a corpse, you can get sued. So, funeral directors have to be aware. Foreseeability, of course, is important in mental anguish. The Supreme Court just kind of gave us more analysis on how we can prove things. In essence, they made it a little harder to prove, but if you study the case, you can go through the right elements and get the language in there. What I like to do, whenever a new case comes out and I'm crossing somebody or presenting somebody, I outline the case and I have it right there next to me, so that I make sure this is what summary judgment's going to be. I need to beat it. So I check the questions to make sure I have all the things the Supreme Court has said, so that if I go, especially on a big damage, and your mental anguish are going to be big, hopefully, because of the suffering the family had for losing somebody. If you don't do this right, you may get $1 million in mental anguish and the Supreme Court or Court of Appeals kicks it out because you didn't go through the motions. So make sure that you study the recent cases of 2018, Funeral Home Services versus Nelson, but it has been changing. This is just the last piece, the last shoe to drop, because the old aggravation versus humiliation, that's been put to the side. The pattern jury charge doesn't even have that anymore. Pattern jury charge talks about the interruption of your everyday life kind of language. Okay? All right. I forgot I added this, and I'm going to go fast because I want to be on time. I'm one of those people, 6:58. So this is important because I just tried this case, the 18-wheeler case. Digital event data. If you know anything about not just 18-wheelers, every car almost that's out there in the parking lot is going to have tons of data. And so I have an expert. As soon as I get a car wreck or a commercial policy or something that I know is worth spending the money, I get him to go over there and they start downloading all kinds of data. When you connect your phone to your car, do you know that you're downloading GPS, texts, emails? You're downloading all kinds of stuff to the brain of the car. So literally, my expert can go and get all your texts that are going to the car through your phone. They're in there. I kid you not. It's dangerous. He was hired on a divorce case for those people who do family law, and it became crazy business. 'Cause he was able to get all that stuff. He was telling me about it. I'm like, oh goodness, I'm glad I don't have those issues. But seriously, the electronic data in your cars, and all the new cars now have it. Of course, the trucks have been doing that for a long time, but even more so now. So make sure, if you think you have one of those cases, that you hire or call somebody, get somebody out there to do the downloading. In the case I tried in South Texas, it's clear liability, but you know what they did? They sent the truck back to operations after a ruling for us to inspect it, and after a preservation letter. And they did it on purpose, sent the car like to Wisconsin, the truck to Wisconsin and back to override the data. And it overrode a lot of the data, but the way those things tape, I say tape, I don't understand the system, but the way they record it, it's not like a straight tape. It's like jumping. It's weird. It's something the scientists know, the engineers know. And so when you read it back, you can read it piecemeal and then put it together. And of course, I don't know how to do it, but the computer has logarithms that they put it back together. So they overrode some of it, but not all of it. And because an event was created when the wreck occurred, that's preserved like in a little box. An event like a serious wreck or a serious break. So that was very interesting that I learned a lot more about this. But this is something that's happening every day in the litigation world. Most common areas of digital event data, passenger vehicle airbag modules. I've had a lot of airbag failure to deploy cases against Ford, GM, and all the big wigs there. And when the airbag doesn't deploy and somebody gets injured, there's a way for you to prove that, depending on the injuries, the airbag would have saved them. Why? Because the automobile industry has done tons and tons and tons of research to show how airbags protect. When you fail to protect, and how do we prove it? Electronically, data-wise. There's a signal that says that the airbag wasn't functioning, and it should have been functioning, and it's like real electronic engineering science. It's nothing, I can't simplify it more than just bring an expert and explain it. But that's how you prove it. And so when you got the right experts, you got the right injuries, the right facts, it's worth going after. I get calls all the time, hey, my airbags didn't deploy. What happened? Nothing. Okay, that's bad, but I'm not gonna spend, $100,000 to get an expert to go prove the airbag wasn't working. So it just depends. Tractor trailer, we talked about that. GPS, it's not just the equipment in the vehicle, but there's a GPS satellite that's tracking these trucks wherever they go, like our phones do to us, so you can get all that data. And dash cameras, remember I showed you that. The 18-wheeler had a dash camera. It worked out great for them. You won't believe this, but the case I tried in South Texas with the Vietnam veteran, he was a helicopter pilot for all his years in Vietnam. And so he's one of those guys that says, by golly, I'm gonna have a dash cam in my pickup truck. Because if anybody hits me, I'm gonna show that it's not my fault. Sure enough, he's driving that night and he has his dash cam, and it's a beautiful video, and the 18-wheeler made a U-turn across all lanes of traffic on 71 near Austin, and the reflectors were old. It was an old tanker, and when he sees it, it's too late. He hits his brakes. You can see it. You don't see it at first, and then when you see it, it's too late. He hits his brakes and still hits it. So the dash cam worked great for us in that case. It worked great for the trucking company in the video I showed you earlier. All right. I think we've covered when can you use it. It's a lot of different scenarios, but this is the last one I'm going to show you. I know this is the end. It's turned sideways, but this is a spine, MRI of a spine. And you see something weird? See this thing right here? That's the way it's supposed to be. See that thing? That's a massive tumor that was sitting inside of the spinal canal of this baby child that unfortunately went undiagnosed for many months until she was paralyzed from the waist down forever. And I hate to say it because my children all go to Texas Children, but the folks at Texas Children missed it, and the poor child is paralyzed from the waist down. When I showed up to mediation and I started putting on my little presentation, this is the simplest presentation I can show. But when I can tell the adjusters for the hospital that we trusted them and they failed us, and I show this, it's over. And of course, a lot of depositions later, but they did pay. And again, this is the simplest. When I showed this to the focus group, this is all I needed to show. I said, what? Texas children doctors missed that? And she's paralyzed? Bring me the checkbook. And so I give you this of witnesses and evidence because I'm not Mr. Smarty Pants. It's just I've been doing it for a while. And so you learn all these techniques to become better and better at presenting your evidence. So obviously there's a lot of conclusions. Be prepared, and it's crucially important to preserve your evidence, whether it's digitally or through your witnesses, and make sure you prepare your witnesses, more importantly, because the witnesses are going to make or break your case. All right? That's it. And it's 6:54.
You did awesome. So we are so thankful that you came. This is a small token
Thank
from
you
all of
so
us,
much.
and it was very enjoyable. I learned a whole lot. So
appreciate
thank
it.
you for coming. We're going to take a 5-minute break. So we're going to start back up right at 7 because I want to commit to our time frame that we said. So we got a 5-minute break, and then we will introduce Fred, who will be our second speaker, who I think at least some of his stuff may.
Relate.
That ending was great.
That's what I thought. So, and it wasn't even planned. So 5 minutes and we'll get started. Thank you.